Maneva na sema PENDREAM TV. PENDREAM TV de osia dem yopo.
You are once again welcome to PENDREAM TV, the only channel that brings you the best and latest updates in politics. If you are new here, please don't forget to subscribe to the channel, hit the notification bell for more updates, like and also share to other members to watch as well. You can also leave a comment after watching or send us a voice note on our WhatsApp number showing on your screen as well. Thank you.
Some sense of laxity when it came to other issues as well. But the NDC side of the house, they call themselves the majority caucus, so to speak. And they address a press conference. Ato Kesel Forsim, and on, of course, governs Kwame Agboja also in the thick of affairs.
In this 8th parliament, we will jealously protect our new majority status and will not bow, retreat, nor surrender our lawfully earned status. We will also not abdicate our responsibility to the people of Ghana, no matter what. We are fortified that the proceedings of Parliament shall not be impeached or questioned in any court or placed out of Parliament. Any interference with the business of Parliament is unlawful, unacceptable, and shall be resisted. It is indeed true that we will use our new majority numbers to benefit Ghanaians by introducing private members' bill to remove the e-levy and to reduce the suffering of the people of Ghana. It is also true that we will use our new majority to remove the betting tax and other nuisance tax.
And Edudzi, the question then is, why this posture?
Okay, so it's important that matters are put in proper perspective. You see, the 1992 Constitution mirrors our history, how checkered our history has been. So if you recall, in 1979, Kwekuba got elected as a member of parliament on the ticket of a political party. He comes to parliament and within some whatever says he's no longer a member of that political party. But he still wants to remain as an MP. And in fact, remain as an MP until the 1981 coup d'etat. Now, with this background and the fact that a major political party, possibly with the benefit of money or anything, can induce somebody to quickly cross carpet to another end or even leave his own political party. So when the 1992 Constitution was being put together, mindful of this history, we inserted Article 97G. And the whole essence of that constitutional provision is to say that if you are elected on the ticket of one party and you come to parliament, for whatever reason, you must remain there. If you decide voluntarily that you want to leave that party to a different political grouping or party, you should forfeit that seat by way of vacancy declaration. Now you note that, for instance, Professor Wayo Seni came to parliament on the ticket of the NDC, even though he used to be an MPP member. Then in 2006, for whatever reason, said he's no longer an NDC MP and that he had cross-carpeted to the other. Then we said, no, the Constitution doesn't. That by-election brought lawyer Inu Safuseni. All these things mirrors a particular history. Then came 2020, where in this case, an NPP MP, in the person of Andrew Esiama, lawyer, took the initiative to contest the 2020 election as an independent candidate. Now, when he took that decision, his party cited the party's own constitution to say, a member who takes such an enterprise forfeits his membership. And since he's no longer a member of the NPP, he cannot continue. What is required in those circumstances is the declaration of intent. That declaration of intent of formally filing. And in this particular case, all the affected individuals, Honorable Kwachiaka, had actually filed his nomination with the Electoral Commission as an independent. Honorable Andrew Esiama had filed his nomination with the Electoral Commission as now MPP candidate. Morrison, what's the name? Cynthia Morrison had also filed his nomination. So the issue of they filing their nomination is a matter of fact. No dispute whatsoever. So when the minority leader then, now majority leader Keselato Forson, raised the issue, the speaker considered it worthy to give a ruling. But you see, like I always say, when this matter came to the speaker, he exercised a lot of sobriety, a lot of patience, and said, look, give me 2 days to consult broadly and deliver a ruling on it. And therefore, he delivered his ruling. Now, guess what? What was the ruling of the speaker? The ruling said, look, I am aware of a precedent set by my predecessor, Professor Michael Quay. However, I am not bound by that precedent. But looking at these facts, I am minded to do what the Constitution says should be done. What is the issue? Now, prior to that, Alex Afenyo-Markin had gone to the court. Now, listen carefully. To even stop the speaker from going ahead with the declaration by way of an injunction, the speaker gave an indication that he has not been served with those processes and proceeded to deliver his ruling. Guess what? What Afenyo-Markin was seeking was an injunction to restrain the speaker from making the declaration. The speaker had declared those seats vacant, and they stand vacant. How do you reverse that process? Because as at Friday, when Afenyo-Markin went to court, he had not amended the original action. It is the original writ that invoked the jurisdiction of the Supreme Court. Now, you cannot put an application on nothing. An application should be mounted on an existing action. So the originating motion is not the application. It is the writ. That is what invokes the original jurisdiction of the Supreme Court. Now, Afenyo was seeking to stop that thing from happening. As at the time he went to court on Friday, that thing had happened. Like we always say, you don't grant an injunction where the horses are bolted already. The injunction is to stop the horses from moving. Now the horses have moved. So what would be the basis of granting an injunction? So you see, the court then cleverly said, then they are staying the execution. The fundamental question every lawyer will ask, the decision by the speaker, the ruling by the speaker, is it an executable order? If it is not an executable order, what would be the basis to say it? Two, I have gone through the law reports, and I've been trying to look for a precedent where the Supreme Court of Ghana from 1992, per an ex parte application, stayed the execution of an order. There is none. Are there anybody to do that? In fact, if you recall, Tenadi, even that one, the Supreme Court had to do an extraordinary step of restraining the Electoral Commission. It was on notice. A major matter of this nature, to grant an ex parte application makes it extremely strange and bizarre. But you see, I have looked at the reasoning behind the Supreme Court's decision to stay the execution of the order. One, the Supreme Court says there are special circumstances. What is special about it? Did the Speaker stop now minority from conducting the business of government in the House? They voluntarily walked out. Now, where a person has a right to conduct government business, and that person voluntarily walks out of Parliament, how can that same person now complain that it will affect government business? In any case, walkouts are legitimate exercise of parliamentary work. And that is why all over the period from 1992 to date, even when there have been walkouts, business of government had always run. So it was so strange that the Supreme Court now relies on a purported whatever frustration of government business. At that point, the Supreme Court had now moved into the realms of politics. It is no longer law, but it's doing politics.
How can you accuse the Supreme Court of meddling
No.
in the daily affairs of the politics of the country? Edudzi?
Because you see, the running of government, the governance, is an executive action. So when, for instance, the executive brings a bill to Parliament, and you are saying that by reason of the ruling by Speaker, that bill cannot be taken, that is a different matter. In this case, Apenyomakin instructed his group to walk out. He was not denied the opportunity to transact government business. When he voluntarily decided to walk out, it lies foul in his mouth to now complain that government business will be affected. So the very moment the Supreme Court cites this instance as one of the grounds to stay the execution, they are now doing politics and not law or policy formulation. And you see, there's always a danger with the court, activism. Look, I'll tell you this. Jachi Kwesi, who injuncted Jachi Kwesi from performing his duties as a member of Parliament?
How do you mean?
Who injuncted him? Was it not the Supreme Court?
The court, yes.
From 1992, do you know any MP that has been injuncted before? Do you know? The panel that injuncted Jachi Kwesi included a CJ.
The current CJ?
Yes. At the time when they injuncted Jachi Kwesi, the people of Asinop were not denied representation until the by-election.
Why is this important?
Because the court now says that these persons whose seats have been declared vacant will be denied representation. Is that a double speak? When the court injuncted the Honorable Jachi Kwesi from performing his duties pending the determination of the action by the Michael something, the court was not mindful that the people in Asinop will be denied representation. Now you see, the curious thing about all of this is that the Supreme Court says these people will be denied representation. Curious. We have been in this country when one morning the Electoral Commission on the 6th of December, by a stroke of pen, denied the people of Central Kofi, Akpafu, Likpe, Lolobi representation in Parliament.
Are you accusing the Supreme Court of double standards?
I am saying that we were in this country when the people of Central Kofi, the people of Akpafu, Likpe, Lolobi were denied representation for 4 years at the time when matters were in our courts. In fact, when a court took the extraordinary step of injuncting Amewu, the Supreme Court intervened by way of its supervisory jurisdiction to quash that. Look, I have always maintained that we are building a constitutional democracy. This constitutional democracy that we are building, we need to carry our people along. Where the impression is being created that when the action borders on Kwejo, the speed, the alacrity with which it is dealt with, but when it has to do with armor, laxity, it creates a certain impression. And I say this, I represented the NDC, yes, September last year. We issued a writ because the EC had, planned conducting the limited exercise in their district offices. When we went to the court, guess what happened? When we went to the court, it was the vacation. When we went in, guess what? The registry of the court gave us October, by which time the EC would have been done with the exercise. October. Meanwhile, in 2012, when Afarijan decided to create the additional 45 new constituencies, Ransford, France went to court led by my then company law lecturer, Govt, to stop the process. It was during the legal vacation. The then Chief Justice, George Nawood, put up a sole panel. Justice Julius Ansah, may he so rest in peace. He presided over the matter during the vacation and gave a ruling. For me, my point is that the application of these rules must appear even. Look, justice delivery is founded on public confidence. public confidence in the sense that when Edudzi and Roland have a problem, we should have the confidence that when we go to court, the outcome, whatever it is, we will take it. But where we have any doubt that we'll go and this and that is what will happen,
Edudzi, wrap up.
eventually what you have is what we call self-help. Because then when you have the problem, you don't want to go to the court. What you want to do is to take the law into your own hands. And that is why I find this ruling by the Apex Court extremely concerning. It doesn't send the right signal to our people.
What sort of signal does it send, Edudzi?
You
are an officer of the court.
Yes, and that is why I'm even more concerned. That is why I am even more concerned. Because listen to me, as Director Legal of the NDC, I have an important role to advise the party on key legal issues. With the things happening, what will be the basis on which I will look my party in the face and say, take these A, B, C, D steps? Because my own people will tell me that, Edudzi, you say we should go where? We should go to court. And so I am saying that we have gotten to the point where the rulings coming from, particularly the Apex Court, relative to matters with political undertone, do not send the right signal.
No. What do you make of the NDC caucus all the pronouncements they've been making in the public domain?
You see,
just 4 minutes on this, please.
Yes. You see, Roland, you see, when you have two children, when it's time when you have two children, the way you respond to their concerns give an indication whether as a parent you are really parenting well or not. The reason why I make this point is that the NPP currently have this feeling and they are emboldened to demonstrate a lot of impunity in this country because they believe that there are no consequences for their action. That is the current mindset of the NPP. You see, the only reason why we are here is that the NPP is running away from the precedent they set in the year 2020. That is the only reason why we are here. When Okwe gave that ruling against Esiama, listen carefully, it didn't bother them because at that time they had a lot of, they had a comfortable majority. And so whether Esiama was available or not could not stop them from conducting business. But you see, anytime you take an action that is short-sighted, an action that is not informed by other implications, you get to this point.
How was that short-sighted?
Okwe ruling was so short-sighted that he didn't also look at the reverse. A situation where you have only one majority and you are losing one, what will you do? You see, this morning, my friend here makes the point that, and you see, he states the law in ex parte lie and applies it wrongly. Ex parte lie only deals with the situation where judicial processes or whatever that requires a hearing, you have not been heard. That is what ex parte lie says. The fundamental question in applying ex parte lie is to ask yourself, who is in court? Is any of the affected MPs in court? So at best, per your reasoning, Afenyo Makin is at best a busybody. Is he one of the affected MPs? Has his seat been declared vacant? That requires him to go to court to allege a breach of natural justice. What law are we propounding? Where you have not been affected directly by a decision, you go to court and say, I'm complaining about somebody else.
What if he's going as a head of the majority caucus?
Please, was a decision taken about the majority caucus? Individual seats have been declared vacant. The 4 MPs, none of them is in court. That's an afterthought. They have lost all defenses. So basically what they are doing now is to be running octopus all over the place, trying to find a reason to hold on to. None of the affected MPs is in court.
The Speaker, what should be his position tomorrow?
I will deal with that. You see, I have always maintained, yes, the only reason why Russia or the United States of America has never attacked Russia, do you know why? because there's something called mutually assured distraction. Listen carefully. Mutually assured distraction. The US of A knows that if they fire a missile into Russia today, Alaska is just a distance away. You see, where people decide to disrespect you in a co-equal manner, what you do is to assert your authority. If you remember the famous US case, the Still Seizure case, Justice Frankfurter has something. He said the concept of separation of powers is to demonstrate separateness, but interdependence. You need a situation where these co-equal arms of government must respect each other. The manner in which the court intervened, the speed with which the court intervened is becoming one too many. And I'm worried. Look at the manner in which Parliament passed a bill. And then somebody goes to court and says, we are injuncting the transmission of the bill so passed to the president for assent. And today the matter is in abeyance. When you do that, what you are doing is that you are using the Constitution as it were to project a particular mischief. And that is extremely dangerous. I'll conclude on this. Oh, no, let me just 30 seconds on this.
Because it was how many more minutes?
If you read,
he's past 2 minutes.
If you read Article 99, Article 99 says the High Court shall have jurisdiction to hear and determine any question whether, listen carefully, the seat of a member of parliament has become vacant. What the Supreme Court, it's a question whether the Speaker can declare those seats vacant or not. How is that a matter for the Supreme Court?
What should be his posture tomorrow? I asked you that question.
And that is what I said. I gave you the example of US. When people know that their actions have consequences on others, they will sit up. And so I strongly believe that the Speaker is the head of a co-equal arm of government called the legislature. He must assert the dignity and authority of Parliament tomorrow.
But that could lead to a constitutional crisis. 4 minutes for you.
Yeah, first of all, Edudzi should not present it and make it look as though the NPP only went to court to file for an application for stay of execution. There is a substantive suit that is sitting, at the Supreme Court.
Very well.
Yes,
very
and
well.
That's
public knowledge.
Yes, and that substantive suit has to do with whether or not the declaration made by the Speaker, he had the powers to do so. So there's an interpretative question. So Article 99 doesn't come here in the first place. Let me land. No, you can. If I'm wrong, you can. Let me land when I finish with my submission. Article 99 doesn't come here. Don't defer it to the High Court, because there is a question of interpretation here where the Supreme Court has to make a declaration. Again, I think reference was made to the standing orders where you read it on television for everybody to see. It is instructive to know that even in the standing orders, at no point did the standing orders require the Speaker to make a declaration of seats.
Read what the Speaker said. No.
Should I get up and go? What is this?
No. Please let him have his. No. Edudzi.
Correct. No, I will not allow you. Stop that. Wait till I talk. When you are talking, you think we are not misinforming people. When we are quoting Article 99, when we are quoting Article 99, misapplying it wrongly, you think we are not misinforming people.
What did the Speaker do?
What? Oh, Edudzi.
No, please. We'll play the video of the Speaker. Please get a video of the Speaker.
I will even move beyond that argument.
No, your 3 minutes is short. Please go on.
I'm saying that even if we read order 18 of the...
Thank you for staying tuned. PENDREAM TV really appreciate your time. Please, if you have not yet subscribed to the channel, please do so for us. Hit the notification bell for more updates. Like and also share to other members to watch as well. You can also leave a comment after watching. Thank you.
PENDREAM TV now, so far so good. Say open online portal e Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.